A very good afternoon to the participants here today, and thanks for the kind invitation to come here and present today to the organizers. Thank you very much. And to you, Mr. Finney, I would like to say that we have a wording in my country which goes as follows: it's the guest who brings the weather. We normally use that to push a little bit to one another in the cold north, where the weather, as you all would know, is rather unstable, and I'm sure that we have other guests present here today which have brought this beautiful weather. Right. The subject that I've been asked to talk about here today is to give you an update on the Unitary patent system, with especial emphasis on the UPC. I have included a small slide in the deck, which I understand is in front of you, about the Zacco company for which I'm the vice chairman. And feel free to look on it, and we'll be glad to answer questions if you have that. And with these words, I'll jump to the subject of this presentation. Now, when we do these presentations, it's very often so that it is necessary to make a quick look back in order to explain why the process is as it is. And that look back will obviously take its point of departure in the decision in 1973 of the European Patent Convention, which is an intergovernmental agreement that established the European Patent Organization and the European Patent Office. I've had the pleasure to be the chairman of the European Patent Organization for 7 years, in which time we negotiated the UP and UPC program. Now, I think it was a major achievement that the European countries obtained in 1973 to establish a centralized prosecution procedure in Europe, which could bring to users, as an alternative to use the national rule, a highly qualified, stable, and effective patent prosecution system. But it is also clear that when the decisions were taken by our political masters in 1973, they only went half of the way, because there was an important component who lacked, and that is obviously to include a system for litigation when it comes to infringement and validity issues on a European patent. The way the system functions today is that a European patent can be validated. That is to change a European patent into a national patent in the respective contracting states to the EPC. We call it therefore the bundled patent. So it is a European patent, which in itself does not imply legal capacity to be enforced. But once being validated into the various contracting states, it has that in the form of a national patent. And I'm sure that all of you, especially our distinguished guest from Japan, will sit and consider why are the Europeans making such a complicated system. And I think that the best answer I can give to that very legitimate question is that it is a long process to integrate a large area consisting of countries who have in their own rights developed their political culture and processes over many, many years. So, is it better?
Much better, thank you.
So let's move on. Ever since 1973, I think you could say that we have tried from the various national governments and from the EPO to run processes with the objective to establish a court system on top of the EPC. Various attempts have been made. We have been sitting with a full-fledged agreement ready to kick off for signature when the whole thing fall apart due to broader political issues which emerged. Now, why are we now in a situation where it is important to make the reform? And I think it is quite obvious why. It is simply so that the value of intellectual property has grown to be such an important part of the value of industrial corporations and businesses today that this area in itself cannot entirely be led to the experts to run, but that we also had to have a political process which reflected the fact that the intangible assets of companies today are by far the most important component when you look on the total value of a corporation. So in order to develop Europe as a region here in the world, it was necessary to take these steps. And I think that if you look on other countries, and there's two other countries which immediately drop into my mind, and we'll talk shortly about it, you can see that we have this phenomenon of the economic development going forward by the inclusion of intangible assets, and then the IP system lagging a little bit behind but coming up as the development progresses. Now, we also had a couple of other problems with the current system, and one of them is that if you look at small and medium-sized companies, and I have obviously taken notice of the cooperation that you have established with the collaboration between the EU institutions on the one side and the Japanese authorities on the other side, in order to spur the development of SMEs. For SMEs in Europe today, I think it is fair to say that it is very difficult to deliver justice in infringement situations if you have to run a complicated system where you have to enforce your right in several countries and at the same time. Small companies simply cannot afford it. So in order to develop our SME sector in Europe, it was important to take the next steps now. I will say that it also goes for our foreign partners, and that can be Japanese companies, but it could also be other companies from other countries. It is a little bit the same. The European system is too complicated, and we need to single out one court system within the frame of which that you can fight for your rights. Oh, that was the wrong way. Here we go. In 2012, the European Council and the European Parliament finally decided on the agreement to establish the Unitary Patent and the Unitary Patent Court. It was under the Danish presidency, and I can testify here today that it was very complicated negotiations. Of the various reasons that I've already mentioned. We have traditions in the various European countries for how we conduct our business that we would like to maintain. But forming a truly European institution, a compromise obviously needs to be struck. And I can perhaps say more explicitly that the most complicated discussion were to find a solution to the fact that we in Germany runs the process of bifurcation, whereby we separate the issue of invalidity from the issue of infringement, to get that tradition integrated into a tradition that we have perhaps more dominantly in Northern Europe for oral proceedings, where we are taking everything in one go. That took half a year of negotiation with the experts and the representatives from the various countries to find a solution. Now, when I talk to colleagues from Germany and from the UK primarily, none of them are satisfied because they couldn't get what they wanted. But the rest of us are very satisfied because we actually found a compromise that we all now believe can work. So it was a great accomplishment for Europe that we were able to sign the agreement in 2012. Now, looking forward, and just some facts, it is so that 16 states, including the 3 big states, which is France, the UK, and Germany, had to ratify before the UP-UPC system would go online. The status today, 13 states. The status today is that 16 states have ratified, including France and the UK, and we are lagging Germany. We have 2 issues in front of us. One issue is a clarification on a constitutional complaint that has been filed in Germany to the German High Court for Constitutional Matters located in Karlsruhe. That claim has been pending in front of the court for a little more than a year for the time being. The other issue we have in front of us is obviously the ongoing Brexit negotiations, and as most of you are aware, we have a very hard day in front of us, which is called the 19th of March 2019, where Brexit will indeed happen. The original plan for how we should get the UP-UPC system up and running were that we will be able to ratify and initiate the process before the 29th of March 2019. However, the situation in Karlsruhe has led to a situation where that is unlikely to happen. Now, talking to colleagues around in Europe, it's my gut feeling that we will have a situation where we can hope for that we will have a clarification in Germany on the constitutional issues within the next month. I have written 6 months here. That might be a little bit too optimistic. It is, as I'm sure you're aware, completely in the hands of the Constitutional Court in Karlsruhe to make the decisions. And but for the purpose of planning, many of us who are around this discussion think that half a year from now is a reasonable forecast. Now, if the Constitutional Court decides that the agreement is within the frame of the German Constitution, then we would expect that ratification will take place rather fast, and that will obviously lead to having the system up and running by the end of 2019. Now, if the German government have to go back to the Bundestag again, which is also likely outcome of this event, then I think one should add in yet another half year. Brexit. If any of you can answer the question of whether we will Brexit or not, then you are very fortunate. I think that we in the IP world are simply looking on the issue in the following way. All of us would love to have our UK colleagues and the UK industry involved in the UP-UPC system, but we have to await to see what will happen. And it is my expectation that the participation in the UP-UPC will be part of the final negotiations on the Brexit. So my assumption is that we will see that the UP-UPC system will go on before there is a decision on the Brexit situation. Now, they might Brexit, but there might also be follow-up discussions at a later point in time. So, I think that when you plan your future patent processes, as Japanese enterprises and Japanese advisors, should base your advisory and your decision-making process on the presumption that we will indeed have a UP-UPC system in Europe within a reasonable time frame. And whether that will be 1 year or whether that will be 3 years, that is a little bit difficult to predict. But my best guess is that we will see the UP-UPC up and running. And that raises a whole set of new questions that especially Japanese corporations must consider. It is so that in the agreement it is possible, it's built in that it is possible to opt out. So that is to say that you will still just obtain your traditional European patent, which will be transformed into a bundled patent, as I described before. The other possibility is to stay within. And a third possibility is to opt out in Italy, having the right to opt in again in a later point in time. So there's various considerations that one should undertake at a corporate level, and that advisory to clients must base itself on when we go forward with this process. And these issues are rather decisive. Now, I can perhaps inform you that it is my expectation that a rather large part of the US, the American, Anglo-Saxon pharma companies will initially opt out because they would like to see how this new institution is functioning, and perhaps also see some case law coming out of the processes to fully judge the value of the new system going forward. I think this is a consideration that I hear quite often, and there is certainly elements of merit to that strategy. Now, if you look on the mechanical industry, the electronic industry, and the digital space, it is more likely that you will see that industries will stay in the system and not opt out. Again here, the reason for that is that the life cycle is shorter for these industries, hence the risk of not knowing precisely how the new system will operate is bearable, especially taking the magnitude of patents into consideration that is filed for these industries, from these industries. Our good Japanese colleagues and representatives from the industry might want to consider going forward. Now, a few remarks on the current situation in Europe. It is so that we are still seeing a rather high growth level in patenting out of national-based companies. We see that especially the northern European region is having high growth rates in patent applications coming in. And we also see that patents related to the digital space, to artificial intelligence, to blockchain, to all kind of big data and big data analytics are surging with growth rates between 15 and 20% in these spaces. And this is obviously a reflection of the dramatic change that is undergoing globally in industries caused by digitalization. You can see some of the same traits in the US figures. Here in Japan, I presume it is a little bit the same, and in China, this is even more pronounced. So the competitive landscape is also changing a little bit. And I'm mentioning this because there will be an intervention later today where some of the details of this will be looked a little bit on. But I'm also mentioning this because I think this is a driver behind the need to get through with the UP and the UPC system. Because we need, in such a more digitalized world, where product and process development accelerates caused by the digitalization, we need to have a more efficient system than the one that we have today. Now, it has obviously ramifications also from the national patent offices and from the EPO, but I think in order to keep the focus, as our two initial speakers here talked about, let's keep it at that. So I thank you very much for the word, and I'm very well prepared to take questions.